Hi guys, welcome to the show. And again, it's Manu
and Dom
with
That.
Welcome to the show. And if it's your first time here, you want to go back and watch the other episodes. So the purpose of the show is to talk about horror stories that can happen with real estate. And tonight we're going to have a special guest on the show. We're not going to reveal who it is yet. So stay tuned. It's gonna be
You'll
juicy.
love it.
Yes. Mm-hmm. Welcome everybody. So today we are here with attorney Paula Miller with Compass Law. Paula, say hi.
Hi everybody, I'm Paula Miller.
Okay, so Paula, thank you for coming to Tete a Tete. We are talking about what horror stories that are in the real estate world, right? What can happen, what resources are available to folks, and what they can do in order to get out of, certain real estate mess that they can find themselves in. So today we have a story. Let me get my information. So Paula. So the story today is two people were dating, and they decided to buy a property together. After a little bit of time, they were separated.
It happens.
Yes.
Wouldn't it be nice if everybody came up with the agreement in the first place when they bought the house? What would we do if we were separating?
Yes.
Because when people start out making a promise together and say, what if this all breaks apart, what are we going to do then? They at least come at it with good faith at the beginning because they're in a good headspace of trying to make it work, and they come up with an agreement that's fair because they don't know who the person is going to potentially be in the wrong if everything falls apart. Unfortunately, if there's no agreement made between people what they're going to do with the house if they were to separate and then they do end up separating, it's more emotional than making it fair.
Yes, absolutely. And we've seen that happen. People separate, and instead of finding the fair solution where everybody could come out happy, it's I want it all.
Somebody feels like they need to win because they need to win the breakup, but their heart was broken through it and things didn't end up the way they wanted it. And so then they use the property as the chip to try and get more or win or fight it out longer or stay in each other's lives longer than needs to be, because they need to find a solution to what's going to happen with this property.
Absolutely. So Paula, the story is two people were dating. They decided to buy a house together, and both their names were on the mortgage, the deed, and the note.
Okay.
They separate, and one of their names was taken off the deed of the house, but left on everything else.
Unfortunately, if they had done this the right way, through the process of taking his name off the deed, should have been done at the exact same time of making sure his name got taken off the note and the mortgage. Because the note is really the promise to repay, and if that is not being paid, it'll affect both of their credit because it is joint and several liability, especially in Massachusetts. Everything is, most other states as well, but the note and the mortgage responsibilities are joint and several liability. Okay. So it's not like you can say, oh, he didn't pay his half, she didn't pay her half, but I paid mine, so it shouldn't affect my credit. It doesn't work like that. If the mortgage doesn't get paid, then it dings both of their credit. So he kind of lost all of the power by taking his name off of the deed, agreeing to take his name off the deed, and not enforcing that his name should have gotten taken off the note and the mortgage at the same time.
Okay, but here's another question. What if they had an agreement, something on paper that says, that the other person was going to take the name off of the mortgage afterwards?
Then to enforce that agreement, unfortunately, the best way is to go to court, to start a court process for breach of the agreement, or if you can make an argument that the property was held in trust by the person whose name still remained on the deed for the benefit of taking care of the equity in the property, the mortgage, things like that. There could be a breach of fiduciary duties in that regards as well as a breach of the agreement. Depends on what the agreement said and how strong that is, but then you would need the court to step in and enforce it if the parties aren't cooperating and enforcing their own agreement by themselves.
If I may interject, so my question is that what is If you can break it down into layman terms,
Mhm.
the difference between the deed, the mortgage, and the note.
So the deed says who owns the property, who actually is the owners that have the legal right to the property. That doesn't necessarily mean they have the right to live there. Like owners of the property could rent out the property to tenants, and then tenants have the right to live there. But even though owners still have the ownership rights. In property law, we call this a bundle of sticks. And so you can give the bundle of sticks of ownership of property, you can give one of those sticks to different people. So just because you're the owner doesn't mean you have the absolute right to live there. But the deed is where we look to see who the owners of the property are.
So in that case, it could be a company, it could be a management company, it could be an LLC, it could be a corporation.
An LLC, a trust, a corporation, all of these are different entities that we're fine with owning property, as well as individual people owning it in their own name, which is definitely the most common.
Okay.
The note and the mortgage kind of go together. The note is the promise to repay a lender. A promissory note is your agreement to repay. And if two people are on a note, it's joint and several liability. They're both responsible for the entire repayment. The mortgage goes in line with that because the mortgage secures the note with the property, uses the property as the collateral for the promise to repay. So all of the owners of the property have to agree that they want that property to be used as the collateral for the repayment. Therefore, generally speaking, everybody's name who's on the deed is also on the mortgage at the time that that mortgage is taken out. But not necessarily everybody's name is on the note. So it could be that one person is financially able to get the loan in their own name by themselves, and then they add their spouse or somebody else to the deed as the owner. Both of those people need to be signing the mortgage, even if just one person is responsible for the payments and just one person is responsible for the note. So these three things interplay with each other all of the time, but you can't really take your name off the mortgage, off the note, without permission of the lender or doing a refinance. And most of the time, the lender just wants you to do the refinance. They don't want to give that permission.
Okay, Paula. So the next question that I have is, what is the correct process if for the situation that I explained to you where two people are not married, both on the deed, the note, and the mortgage, they want to separate? What is the correct process into going their separate ways and what to do with the property?
The best way really is to decide if one person has the financial ability to buy out the other person if they want to keep the property. If they want to stay living in the home, then they would get pre-approved for a mortgage in their own name alone and see if they do have the financial ability to kind of buy out the other person's equity. Then you'd kind of do an accounting to see, did one person contribute more towards the mortgage? Did one person contribute more to the down payment when they bought the property together? To see what is fair and equitable in what the buyout amount should be. And then through that process of the refinance, mortgage just being in the person's name who's keeping the property, at that time, they sign to release their name from the deed, and they're generally getting a check for their equity in the property through that buyout process, through that refinance process. That's most of the time what happens when somebody wants to keep the property, if they have the financial ability to do so. Otherwise, the best way is if they agree on selling the property and then figuring out how to divide the equity in the property, again, being fair to who's contributed what to the property throughout the time that they have owned it peacefully together. If they're not in agreement, if somebody's just being stubborn and they think it should go the other way, you can actually get the court involved in what's called a petition to partition, and the court will force these things to happen. Most of the time with single family homes, it's not really possible to partition one house. A partition would work, let's say you had a two-family property. You could actually partition it into condos, or one person could keep the first floor and one person could keep the second floor.
Right.
Generally, if you're fighting, you don't want to be neighbors either, but it would be physically possible to partition a property like that. Most of the time, a single-family home cannot be partitioned, and the options really are buyout or sale of the property if nobody wants to buy the other person out or nobody has the financial ability to do that. Through the court process, they actually appoint a commissioner. It's generally an attorney who gets paid hourly to oversee the process of the petition of either selling the property or having somebody bought out. Really, if it's a single family home, those are the only options. It's the same options as everybody has before a petition case and after, but through the petition, litigation takes quite a long time and money, and this commissioner ends up taking a piece of their services that they provide to oversee the process, you actually end up losing out on some of the equity to the court process. And so if the options are the same through petition action, as same as they are as the parties would if they were just in agreement beforehand, those options being either a buyout or a sale, it's generally more favorable to the people getting their equity, getting the maximum of their equity, if they can just agree between themselves to either do a buyout, refinance, or sale. But if they're not in agreement, the court is there to help force one of the two to happen.
So it's in their best interest to remove emotions out of the transaction and do what's fair for both parties. Because
Absolutely.
if someone else steps in, a lawyer step in, or goes through the court system, then the court takes its part of it. So everybody loses at that point, right?
Exactly.
Right. Okay. And if there's an option to buy out, it sounds like it's the best option than having to be forced to sell the property in order for you to.
If somebody wants to keep the home and they have the financial ability to pay for it themselves, that's absolutely the best way. But then it's convincing the other person that they need to leave the property, sign the deeds, getting themselves off the property, and take their equity and understand that that was a fair resolution of what to do with the property.
Okay. Awesome. Hey, Paula.
Thank you so much for having me.
Thank you
Thank
so
you
much.
for
Absolutely. Absolutely. And if you guys have any questions, she doesn't work for free. So reach out to us. Yes. money. And she's got a lot of cases right now, so you're gonna have to come through us first before you get to her. Our information is in the bio. Reach out to us, email us, ask us questions, and then we'll funnel them over to Attorney Miller. And again, this is Attorney Paula Miller with Compass Law. Remember that. Compass Law, Attorney Miller. Thank you so much, Paula, for being with us here today. And it is that with Manu and Don.
Thank you
Bye,
so much
guys.
for having me. Bye.
Guys.